Welcome to my presentation, Human Rights at Work, Protections for Cancer Patients in Newfoundland and Labrador. The Human Rights Commission is an independent, at-arm's-length government agency that promotes and protects human rights in the province. We administer the Human Rights Act, investigate and resolve human rights complaints, give human rights information to people, businesses, and community organizations, prevent discrimination through education and training, and we work with community partners on various projects. You can file a complaint at the Human Rights Commission if there is a reasonable basis to believe, one, you were treated unfairly or experienced some adverse impact. Two, the unfair treatment happened in Newfoundland and Labrador. Three, the unfair treatment happened within the last 12 months. That's our limitation period. Four, the unfair treatment happened in a protected area. And five, the unfair treatment was based on a prohibited ground or protected personal characteristics. And I'll explain some of those concepts in the next few slides. The prohibited grounds or protected personal characteristics are listed on this slide. For our purposes, I'm just going to talk about disability, perceived disability, and disfigurement. However, all of them can apply because we take an intersectional approach to human rights protections. The Human Rights Act defines disabilities as a degree of physical disability, a condition of mental impairment, or a developmental, The prohibited grounds are listed in Section 9 of the Human Rights Act. They're protected personal characteristics, and they're listed on this slide. For our purposes, I'm going to talk about disability and perceived disability and disfigurement. However, all of these can apply to many different people because we take an intersectional approach to human rights protections. The Human Rights Act defines disability as a degree of physical disability, a condition of mental impairment or a developmental disability, a learning disability or dysfunction in one or more of the processes involved in understanding or using symbols or language, and a mental disorder. Obviously, these are very medicalized terms, but that's what the Human Rights Act says. Perceived disability is defined in the Human Rights Act is if you have or have had a disability, are believed to have or have had a disability, or have or are believed to have a predisposition to developing a disability. A disability must also be persistent and ongoing or have a degree of severity or permanence. And there should be some significant limitation on the person's ability to function normally. Disfigurement covers burns, scars, or other disfiguring conditions that are visible but that do not cause any functional limitations. The protected areas are these societal areas that fall within provincial jurisdiction, namely employment, public services, commercial and residential housing, publications, contracts, and membership in a trade union. If your employer is in federal jurisdiction or you're talking about receipt of federal services, you would go to the Canadian Human Rights Commission in Ottawa. Discrimination in law as defined as a distinction, whether intentional or not, which is related to certain personal characteristics and which imposes a burden, disadvantage, or limits access to opportunities in some way. You do not need to prove that a person intended to discriminate. Sometimes it is the effect of unfair treatment, which is most important. What do we hear from cancer patients? And I'm sure you hear this as well. Cancer impacts people differently. There are physical, cognitive, emotional, and psychological impacts. Disclosure. People ask, how and when do I bring this up, a diagnosis up? The decision to disclose is up to you unless it's impacting your work or you need an accommodation at work. And what should I think about before returning to work? Do you have the personal supports needed? Are you ready physically and mentally? What are your current abilities? and you don't need to be 100% ready to start making a plan with your workplace. Will it be the new normal when you return to work, or is it even possible to continue in your current job? What do I need from my employer when I return to work? Do I need accommodations, understanding, help with coworkers? Number one, we hear concern that people could be fired because they have cancer and have treatments or preconceived stereotypes about what a person living with cancer can and cannot do. They cannot fire you simply because you have cancer. They can for other non-discriminatory reasons, or if they've met their duty to accommodate to the point of undue hardship. And again, I'll talk about that in another slide. Employers and service providers have an obligation to adjust rules, policies, and/or practices to enable you to fully participate in society. The duty to accommodate applies to personal needs that are related to the ground of discrimination. This is called the duty to accommodate. Sometimes in order for you to be able to return to your workplace, parts of your jobs may need to be changed. A job accommodation is an adjustment or change to the tasks, work schedule, or environment that allows an employee with a disability to safely and productively do their job. You may not think of cancer as a disability. However, if it affects or your treatment restricts your ability to fulfill any aspect of your job, then cancer may be considered a disability under human rights legislation. So employers and service providers all have a duty to accommodate to the point of undue hardship. They need, as I've said earlier, they need to identify and change any rules, expectations, practices, or procedures that may have a discriminatory effect. All parties, including unions, have a duty to participate. The duty to accommodate should be based on the principles of dignity, individualization, and inclusion. A person's needs may change over time, but the duty to accommodate is not unlimited, and it has a procedural and substantive component. Here are some best practices that we suggest employers and employees undergo. First of all, for employers, we stress the importance of good policies and training for managers and supervisors. We ask that people take these requests seriously and in good faith. You should only request information that is necessary to accommodate. Document your requests and respect the confidentiality of your employees, particularly when it comes to disability-related issues. Get expert advice if necessary, and fundamentally create a respectful, inclusive workplace where employees are not afraid to raise these issues. For an employee, make the request early and participate in the process throughout. Remember, it's called a reasonable accommodation, not a perfect accommodation. And you need to disclose enough information so that the request can be reviewed and a plan made. An employer can ask for medical information. But again, we suggest that it's only enough information so that they can review the accommodation request and make a plan. The nature of the illness or disability and how it manifests itself might be required, and sometimes this includes a diagnosis. Is it permanent or temporary, and a timeline for recovery? So if you're off work due to cancer treatments, they may ask you, what is your estimated time to return for recovery, and when's your estimated return to work date? Do you have any restrictions or limitations while at work? And are there any treatments or medications and their possible side effects which may impact your ability to do your job? An employer or service provider does not need to prove that it's impossible to accommodate a person, just that it would result in undue hardship. Undue hardship is meant to be hard, though, and it does require significant difficulty or expense. What undue hardship means is different in each case. It may consider these following factors. There's financial cost, though there's no need to create a brand new position. collective agreement terms. How interchangeable is your workforce and facilities? The size of the organization? Are there any safety concerns? And the case law does reference morale of other employees, but that's generally not considered a significant factor. What we advise employers to do is go through this process about thinking about other possibilities for their employees. So can the employee do their current job? If not, can it be modified? If not, is there another job suitable and available? Does that other job need to be modified? And can a new position be created? But like I said, only to the point of undue hardship. Here's a list of types of accommodations that we see. Most of them are pretty low cost, though they may involve some thought and planning. So examples include a graduated return to work plan, reduce physical exertion, stress, etc. by job bundling, working with the team, or job sharing. And that might ebb and flow depending on treatments that you're experiencing. Flexible work hours, whether it's working from home, compressed hours, moving from full-time to part-time back to full-time, and possible shift changes. Flexible or extended breaks throughout the day. Time off for medical appointments or when experiencing side effects of treatments. Referrals to EAP or other mental health supports. An ergonomic assessment and adjusted workstation. For example, sit-stand desk, fatigue mat, etc. And flexible deadlines for projects. Again, ebb and flow depending on the effects of treatment. At the Human Rights Commission, the goal of our complaints process is to resolve disputes between parties in a way that is accessible, inexpensive, informal, and flexible. It's procedurally fair. It applies human rights law and principles, is proportional to the circumstances of each complaint, is supportive of the parties involved in the process, and recognizes that there are many other ways to resolve disputes. This is a brief overview of our process. You contact us and file a human rights, we're calling them an inquiry form now. That will just give us a brief summary about what's your situation. Sometimes we can help people, even if it doesn't fall within our jurisdiction, by sending them to other resources or community supports, or even trying to contact your employer to have a conversation. But we do have a jurisdiction framework set out in the Human Rights Act. So we look at that and see if we are able to proceed further with a complaint. If we can, we try to resolve it through voluntary mediation at a very early stage. In some cases, an employer may just not know that they have requirements to accommodate under human rights legislation, or they may not understand that there are other possibilities. If that doesn't resolve, and over 50% of our complaints do resolve at that early stage, we investigate the complaint. This takes some time, unfortunately, and is a highly legal process. So it's not great for people who are going through a lot of stress or treatments at this time. But it is unfortunately what it is. After that investigation, a case summary is drafted and sent to all the parties. And then our human rights commissioners, who are a board, basically a board of directors, and they're appointed from people across the province, decide if there is enough evidence to go to a hearing. Then we have a hearing, a human rights hearing. And again, that is an administrative tribunal with an independent adjudicator deciding if discrimination happened or not. They are required to write a decision, and they can order certain remedies as set out in the Human Rights Act. So that's all I have for now. If you have a general question about human rights, you can email us at humanrights@gov.nl.ca. If you want to find a complaint, file a complaint, you can go on our website and find the inquiry form. And if you're an employer or a service provider and have just a general information question, you can also find a request form on our website. And our website is thinkhumanrights.ca. That's thinkhumanrights.ca. And you can follow us on Instagram and Twitter at NL Human Rights. So thank you very much. And please get in contact with us if you have any further questions. Thank you.